We are now in the part of the day that does not deal with unemployment benefits. For some of you, that will be a nice variety. For others of you, you may not care less. But we hope you find this information helpful and interesting. So most of you know me. I'm Sharon Dietrich. I'm with Community Legal Services in Philadelphia. And my colleague Jamie Gullen will help present this session as well. Thank you for being with us this afternoon rather than watching the Phillies preseason game, which I must admit that I'm tempted to do, but no, we are going to talk about Act 83. In other words, oops, I got muted, but now I'm unmuted. Okay, let me see where my PowerPoint is so that we can get started. Bear with me, folks. PowerPoint, there we go. And we are starting a slideshow. All right. Can you folks see my PowerPoint? Give me a verbal yes or no, guys.
No.
No, okay. All right. Sorry, bear with me. This always seems like it's going to be so easy until you go to do it. PowerPoint, there you are. All right. Now you can see it, right? Unless I hear from you that you can't, I'm assuming you're going to see it. Please do tell me if you're not. I did a whole presentation at CLS recently in which I only found out at the end nobody saw what slides I had dutifully put together. Okay, so talking about Act 83 today. Act 83 is what might be considered Clean Slate II, because essentially it expanded the original Clean Slate, most notably by getting rid of the requirement that your fines and costs have to be paid in order to get your case sealed. That was a requirement for both petition filing and for automated Clean Slate filing. It is no longer the requirement as of the effective date of Act 83. And the law went into effect for petition filing in December. Jamie will cover that at the end of the presentation, but basically the petition part is in play now. The automation part is not yet because the Administrative Office of Pennsylvania Courts has been given a good deal of time to implement the computerization of that. So that won't be coming around until October or so, which of course means if you have clients who are going to benefit from this, you may be wanting to file petitions for them before the automation comes around. So again, basically the key requirement from our perspective about this change in the law is that fines and costs are no longer a barrier. That is the part that we actively worked on. The other two parts are great too, providing that full acquittals are automatically expunged and pardon cases are automatically sealed. And Jamie will talk with you about what that means. I use the word automatically as opposed to automation because these two steps are not being done through automation. And then finally, we'll end by talking about Clean Slate 3, which we hope is on the horizon and will really get us going with getting felonies sealed in Pennsylvania for the first time. So very exciting that that's a possibility. So Before I move on, I want to make clear from the jump, the fines and costs that no longer are a barrier, that does not include restitution. If you owe restitution, you continue to not be able to seal your case until and unless that restitution is paid off, which is not nearly as simple as it seems like it should be. So a great deal of what I'm going to talk about today is the restitution piece and how to get clients through that. So this may sound like it's not that big of a deal, but it's actually a rather huge deal. And I bet that any of you who do expungement and sealing have encountered fines and costs as a problem. Mike Hollander, our former colleague who's now with the Philly DA's office, did some analysis of data about what otherwise eligible misdemeanor convictions were being precluded by the requirement that fines and costs be paid. And the results were really astonishing. Well, maybe astonishing, maybe we all kind of know this, but you know how data, when you actually generate it, actually is very powerful. That's what Mike's work did here. And Mike found that half of the cases in Pennsylvania, the misdemeanor convictions that were otherwise eligible, you know, they were the right kind of cases, 10 years had gone by, et cetera. Half of them were being precluded because people still owed the court fines and costs. So that's even a higher rate in Philadelphia. It's 75%. And so a lot of people simply were not benefiting from clean slate or from petition-based filing because they owed this debt. And of course, this is kind of a cart before the horse situation. If you're demanding people to pay their court debt before they get an expungement or sealing, often they're not in a position to do that because they just don't have the money because they're underemployed. The Philly courts did a study about 10 years ago now, but because it's the court study, it's fairly useful, of who owed court debt to it. And they found that 70% of the people who owed court debt were unemployed and impoverished and basically could not afford to pay that debt. So if you have the requirement that people pay the court debt to get their case sealed, it means a lot of them don't even have that option. So again, Act 83 was meant to deal with that barrier. The racial implications of this are quite marked as well. When you think of Black people as being 19% of the state population, and that being a benchmark here, they actually get a relatively high percentage of arrests sealed by clean slate, probably because of being over arrested with cases that don't go to conviction. But then when you look at misdemeanor convictions, they are underrepresented with only 12% of the misdemeanor convictions that have been sealed by automation. So we think that this change to the rules is going to iron out or at least ameliorate that racial disparity. So that is why both in terms of the numbers and the racial impact, we think that Act 83 is quite important. Okay, this is the exact language in the law now that replaced the language that said you had to pay all of your court obligated financial obligations. Now it says, before you can file, you must make payment of all court-ordered restitution and the fee previously authorized to carry out limited access and clean slate limited access provisions. That latter part is really vague, and the reason is that the courts wanted it to be vague. The courts insisted that that latter language about the fee previously authorized to carry out limited access be in the bill was because they wanted to continue to receive the $8 that they get through judicial computer project fees. And they did not want to emphasize that they were the ones that are getting the fees. So instead, we have this really vague language, but that is what it is meant to mean. Do the county courts know that? I certainly hope so. I can't guarantee you that. I spoke with ALPC about whether they were putting out guidance to the courts, and basically the answer was no, there was none needed. So I hope your courts are not confused about that and refusing to seal cases because they don't know what that means. If they do, please reach out to me and I'll be happy to help, and also to report to ALPC if guidance is needed on this issue. But essentially, that is what that language means, that $8 judicial computer project fee. So as I said, this language, which replaces the previous language requiring all fines and costs to be paid, has gone into effect. Hopefully your courts know that that is the case. Please let them know if they don't, since ALPC has not. We have changed the expungement generator, so it's taking care of the language that gets put into a petition. So it basically only says whether or not restitution is owed. Oh, and by the way, AOPC also meant this language to mean that that $8 only had to be paid if the person also owed restitution and would be making a restitution payment anyway. So it's not necessary for every defendant just to pay that $8 to get their case sealed, because that would still be a massive barrier to automated sealing of cases for the reasons we'll talk about in a minute, because people would have to find a way to pay off that $8, but potentially have to pay a lot of other money before they could even reach that $8 payment. And I know that sounds kind of confusing, but we'll look at a minute as to why that would be a problem. Okay, so of course, we would prefer if the language did not require restitution to be paid, but the General Assembly was not going there because of all of the various fines and costs. Restitution has a sort of sacred place for them as being the thing that is owed to victims. From my perspective, there are victims and then there are victims. Arguably, the Department of Human Services is a victim in a welfare fraud case, and that might mean that somebody would have to pay back, thousands of dollars of restitution before they could get their case sealed. But they're all considered restitution if restitution is what the court order said and what appears on the ALPC docket. We'll look at a docket in a minute. But in any event, the good news is, unlike some other states around the country, Pennsylvania does not enter restitution orders as a matter of course. And, that makes sense, because let's say you have a drug felony. Well, a felony wouldn't currently be sealable, but let's say you have a drug possession case. Who is the victim? There is really no victim, so you wouldn't order restitution. But still, it's kind of remarkable that only about a quarter of the cases in Pennsylvania have restitution ordered. So hopefully it means those other 75% will sail on through. Now, for those that do have restitution that is owed, they are really in danger of not being helped by Act 83. And that is because you cannot just walk into a courthouse and say, I'm here to pay my restitution and I don't want to pay anything else. The law actually allocates payments to various different court fines and costs. And so there are other things that, according to the law, the payment has to be put toward before the restitution can be paid. So that is where this all starts getting complicated. Okay, so this is one of your standard looking court fines and costs listing that you'll find on the back page of a docket that you pull up out of CPCMS, the court's online criminal record system. You're probably all familiar with this. You may not pay a lot of mind to the specifics here, but the specifics here become much more important now that we have this piece of the law that actually distinguishes restitution from these other things. But even as I said, if your person owes restitution, you're not only going to need to know about the restitution, but you're going to need to know about these other things as well, because some of these are going to have precedence for payment over your client's debt. So this page will show how much restitution is owed, although on my screen here, the number that I nicely circled, the balance, is hidden by all of your lovely faces and your Hollywood squares there, but it's there. And it also shows what's owed in all the other categories and what all the other categories are. So this is something you're going to want to consult in any case where you're trying to figure out, is this person eligible to get their cases sealed? Do they owe restitution? And if they do, what about their other debts? So this is the sort of thing you may never have cared about before, but in some ways is the most important thing that I have to say to you today, which is how these priority of payments work. And this is called often the Unified Distribution Schedule. And sometimes you'll see a freestanding copy of it somewhere, but you can also find it codified here in the Pennsylvania Code. And this policy dictates, except where there's a little bit of discretion, how a single payment gets divvied up between all of those different categories of fines and costs that are on the list there and the person owes the money for. And as you can see, they range from the sublime to the ridiculous. Access to justice, something that's near and dear to our heart, that's a whole $1.50 here. OSP, which stands for, well, it means supervision fees. I don't know what OSP actually stands for offhand, but here there's almost 600, looks like $625 between those two listings of supervision fees. So any number of them might have to be dealt with depending on this list of priority of payments. So starting out with the thing that is highest on the list, collection agency fees. That really stinks because they can be really high. There's a limit in state law that collection fees can only be 25% of the overall debt, but the overall debt can be quite high. So that can be a high number. Going back to our little example here, it looks like there was originally a collection fee of $945 on this account. And then it looks like there was a lawyer involved. These are the numbers down here at the bottom of the list of fines and costs. It looks like a lawyer was involved and they put another $1,375 on it. So it possibly, if this had not been satisfied, the person would be in a position where they'd be arguing that they didn't have to pay $2,200. And of course, that would really stink. Now, this all matters because the legislature did not get rid of this whole scheme of the order of payments. I'm not sure it really occurred to them. But in any event, ALPC says this is still in effect. So if somebody owes restitution, they need to get to the restitution here on step 3 of the payment attribution. So the first thing they're going to need to do is satisfy the collection fee. Now you can see here that this person did satisfy the collection fee because there was some kind of an adjustment. My guess was that the person's case was taken out of collections by the Philadelphia courts. And note that the language for collection agencies is not absolute. It says that it is the top priority where the private collection agency has secured the funds. In Philadelphia, the collection agencies get a lot of cases that they take into collections, but they don't do a darn thing to actually try to make the collections. So what we would do at CLS in one of these cases where there might be a case in collections is we would ask the courts to get it back from collections. The person would like to have the authority to pay directly to the court. And our court administration would agree to that. I'm not sure what might happen in your county, but that's a tip of something you can do to make this more affordable to a client, is look at, can you eliminate any collection fees by recalling the case from collections. Even if the person has walked into the courthouse to pay the money on their own, it's not a collection fee that's coming to get the money from them. According to AOPC, if that money gets transmitted to a collection agency to process, they may take the position that they've satisfied this condition, which is of course outrageous. And is why you would argue against that, but it's why it would be best to get the case back from collections if that's something you can do. All right, number 2 on the list, crime victim compensation funds. Let's see where that is on this list. Crime victim compensation funds, right here, $35. So at least that's not a huge part of this debt, but if your client owes restitution, they're going to end up paying that $35, even if they did not have any collection agency fees, but that's going to be a predicate to finally paying off some of the restitution. Okay, restitution is number 3 on the list. And if you could just pay 100% of your restitution, you would be fine, because they would take all the rest of the payment that didn't go into the collection agency fee or the crime victim compensation fund. All the remainder would go to restitution. Now, here is the hitch. The Unified Distribution Schedule says at least 50% of any additional payment. Now, this is really disheartening because let's say a place has adopted that only 50% of any additional payment is going to go towards restitution, and then it's going to go to the rest of these things further on down the list, which basically is anything else that's on this whole list. So that would include the supervision fees, the $625 of supervision fees. You hopefully are not going to find yourself in that posture, because it would kind of require that they pay off everything at the same time, because any payment they made, if the county policy is only 50% goes to restitution, they're never going to quite catch up until they pay everything else. And then Act 83 doesn't really help them that much. Now, fortunately, David Price at AOPC has told me that he thinks that only about half of the counties have adopted a policy that's less than 100% of restitution goes to, or less than 100% of that payment goes to restitution. But you are going to have to figure out what happens in your county. And then just to round out the list here, the Judicial Computer Project and the Access to Justice fee are number 4 on the pecking order. A whole bunch of other things, including supervision fees, are number 5. And then number 6 is everything else. So that is how a person's $50 payment gets divvied up into all of these many other little pots, so that presumably all of the things on this list are having some money put towards them in payment. Okay. We talked about the no less than 50% shall go to restitution. Clearly, that is discretionary at the local level. And like I said, AOPC says half the counties do 100%, in which case none of this matters again, because if there's no collection agency fees that have to go against them, then your clients only have to pay off their restitution and the $35. But if it's less than 100%, then you're stuck in this conundrum of how do you get all this money paid down so that restitution is zeroed out. Here are some strategies for what you might do if you are in a county where there's not 100% allocation of payments to restitution at step number 3. The thing that would have the most systemic response would be to ask the president, judge, or the court administration to do a system-wide change to send 100% of that payment to restitution. And you are likely to get some allies on that. Victims' rights organizations, the DA's office, potentially. There are a lot of people in the Commonwealth that are concerned about restitution and not enough about it being, and concerned that not enough is being collected. So you might find some people to join you in that kind of a request. And that would be a win-win for both our clients and their clients, or the victims that they're concerned about. But another strategy might be to ask the sentencing judge to change the order to 100% restitution payment. I know most of us do not like to go into criminal court, and indeed, maybe there's some restrictions that you would be concerned about. It's not comfortable for any of us at best to be going to sentencing judges and asked for orders to be changed. Maybe that's something that your public defender could do. But both David Price at AOPC and Andrew Christie at the ACLU, who's the biggest advocate side expert in the state, they both agree that this is something that can be done. And then finally, like I mentioned, look to minimize the collection fees if there are some on the docket. Can you get the case pulled from collections? Can you argue with the clerk's office that, in fact, the collection agency did nothing to get this money and therefore should not be getting a piece at step 1 on the cascade? All right. The next part we'll move on to here is with Jamie and the issues around acquittals and pardons. But before we get there, since these are such separate topics, I will take any questions about the restitution piece that we've just gone over, in case you want to know anything more in depth about the priority of assigning payments, or whether you want to know it or not, whether I've been unclear about something and you are seeking some clarity. So I'll take a breath and see if there are any questions for the chat.
Sharon, there's one question already in the chat from Deborah Steves about whether the fines and cost elimination applies to expungements, such as those for those over 70.
I think by its terms, it probably does not, because the language is sealing, right, Jamie? That is used in the language. So only
okay.
So only situations where an expungement might be sealed rather than expunged, which even under auto sealing, the only cases that come to mind are diversion cases, potentially. Might be sealed even though fines and costs are owed. It remains to be seen how AOPC is going to apply this language to those types of cases. But again, we're talking sealing by clean slate, not expungement. And Jamie, did you? I think you were potentially talking with David Price about what their response would be to diversion cases. Did you get any sense of clarity on that?
No, yeah, we were specifically wondering about ARD because it's a non-conviction and whether those would be sealed if fines and costs were owed. But since it's also still technically an open case, our guess is that AOPC is not going to auto seal those, but we're going to clarify that.
Okay, I'm seeing the next question from Kevin is the person's gun rights restored? That really matters, I think, whether it's expunged or sealed, because under sealing, pretty clearly, their information is still available to law enforcement, and our understanding means that a sealed case will be taken into account under the gun check laws. And really, we can't expunge hardly any convictions. The example of the over 70s would be one, I guess, that could be expunged and then should no longer have any impact. But sealed cases, because they're available to law enforcement, will be available even though they've been sealed. Let's see what else we got here. Erica says, is there a proposed order or letter to encourage the president judge to allocate? I'm working on something for the Philadelphia courts, Erica, that I would be happy to share with everybody when it's ready. I am looking still for the explicit authority that says they can do that. And even though David Price and Andrew Christie, who almost never agree on anything, have agreed that this practice can be done, I don't see any explicit authority for that yet. So that's what's keeping me from finishing this up. If I can't find any, I will try to get AOPC to put something out. We'll see whether we can accomplish that. They often are less than 100% enthusiastic about requests like that. Is the generator back up? I believe it is, right, Jamie?
Yes, it should be working again. If you run into any issues, you can feel free to let me know.
Yay, agreed. We all have gotten very used to the generator. It feels like a massive imposition when it's not working. Thank you, Michael Hollander. And now
Sharon?
Nate Vogel. Yes.
Sorry, this is Kelly. If I could just interject myself again, I have to launch the next CLE poll box. So attorneys, please respond. It'll be up for 2 minutes. And Sharon and Jamie, please feel free to continue.
Well, that ends my part of the presentation unless there are any other questions about the fines, cost, and restitution. If there are not, I will turn things over to Jamie. And of course, you can still ask at the end of the presentation.
Great. Thanks, Sharon. And to anybody who doesn't know me, I'm Jamie Gallen. I'm a supervising attorney in the employment unit at Community Legal Services, working with Sharon, focusing on criminal records issues. I'm just going to go ahead and work on getting my screen shared now. Okay. Sharon, can you let me know? Can you see my screen now?
I can, Jamie. Yes, you'll just want to put it in slide mode from the beginning.
Working on it. All right. Okay. Perfect. Okay, so I'm going to start by talking about the automatic expungement piece for acquittals. For many, many years, if you work in criminal records work, you've probably been in this situation too. You talk to clients or go out to do presentations for community groups, and people would say, if I was found not guilty of something, why is it still showing up in the court records? And I would always say, well, that's a great question. You would think that, you know, you not only had charges dropped, but you were found not guilty. Why is this still part of your criminal record? Now, of course, Clean Slate already seals not guilty and acquittal cases, but what this Clean Slate 2.0, as we call it, does is take things a little bit of a step farther to an actual expungement process that fully destroys the record for not guilty and acquittal cases. But the operation of it is a little bit more complex, so we're going to have to see what actually happens in practice with the rollout. But just to cover the basics to start, this piece of Act 83 was added to good old 9122. Those of you who practice expungement law know that statute well. That's where all the different criteria for expungements live. It's number 4 in that list now, and it applies specifically to judicial acquittals and not guilty verdicts. So if you're looking on a court summary and you see a not guilty, or you see a judgment by acquittal, anything with not guilty or acquittal in the subject line, that's what you're going to be thinking of for whether this provision applies. But there is a caveat. It only applies to full and not partial acquittals. And the language that the law utilizes is that all the charges associated with the same conduct or criminal episode must be acquittals. So sometimes in a case, you'll see, there were several different potential victims involved, and there are 3 or 4 different dockets, and maybe somebody is acquitted or found not guilty on 3 out of 4 dockets. But on the 4th docket, they're found guilty or they plead guilty to something. If it's the same conduct or episode, so if it has the same OTN number, the same arrest date, if anything is not an acquittal or not guilty within that, then it's not going to qualify for this. So it has to be an absolutely full acquittal for the criminal conduct or episode that occurred. And the law also says that the expungement must occur no later than 12 months from the time that the acquittal or not guilty is entered. And we'll see in a minute about the procedures that have to go into place between the time when you're actually given that disposition and when the expungement is effectuated. So the procedure is that it's a very court-driven process, so it'll be really interesting to see how this plays out in the different counties, but the court basically needs to provide a notice in writing to the individual and to the Commonwealth, the DA's office, about the auto expungement. And then the DA's office has the opportunity to object within 60 days. But the only thing that they can object based on is that the person has not been acquitted of all charges. So they can't object because they said, well, it might say not guilty, but it was a domestic violence case and we want to keep it on their record. That type of objection can no longer be lodged for these types of cases. The only valid objection is that the person was not actually acquitted of all the charges related to that criminal incident. If the district attorney objects, then the court can hold a hearing just on that issue, or the hearing can be waived by agreement of the parties. And there's also a provision in here, which is kind of interesting since the court's initiating this to begin with, but the court can also make its own determination that the case is not a full acquittal and is not eligible. So basically the way this is all written, it's going to kind of rely on the court to instigate, but then basically as long as it's a full acquittal, there's no grounds for it to not ultimately be granted. So again, we're just kind of waiting to see exactly how this procedure is going to play out. But one aspect that we have been told is that the courts anticipate they're only going to be doing this prospectively, which, as frustrating as that might be, given the kind of procedure that's laid out here, it's kind of understandable. Clean Slate, which was originally done retroactively, of course, relied on computer queries to find eligible cases, making it possible to go back in time and seal 30 million cases. But in a process that's going to require written notice and objections, it was the court's determination that prospective only was the only way to be able to do this. So this is just a practice tip associated with this issue. When we talk about automatic expungements that are happening without an individual taking the step of filing a petition themselves, it raises a potential flag or concern, especially for our immigrant clients who may need records of their cases for immigration and or citizenship purposes. Even for arrests that result in acquittals or not guilties, that paper trail can be important. And so the best practice, and we do this too when we're filing expungements for clients who are not citizens, is to get the certified copy of the criminal record before the file is fully destroyed. So that's just something to think about. With these cases, you're not going to be the one filing the petition, but if you're working with a client who is just acquitted of a case and you're aware that that might be an issue, it's just something to keep in mind to advise folks that they may want to get a certified copy of their criminal record before the file is destroyed. And I think that's also part of the conversation happening with AOPC and the court systems about the implementation of the automatic acquittal piece. I'm going to take a pause for a second, just because I know I've been talking a lot. You guys have been listening to a lot of people talk today, and it's post-lunch and people might be tired. So before I go on to my next slide, if you haven't already previewed and read the presentation, I'm going to ask you a pop quiz question that you can put an answer in the chat to, just to get everybody a little bit more interactive here. So the next piece we're going to talk about is the pardon sealing piece. And I just want people to take a guess and put it in the chat what your guess is, that once people have gone through the pardon process and successfully gotten their pardon signed by the governor, what percentage of people do you think never get their record expunged after that? So they've gotten the pardon, but they never get their record expunged. Put in the chat what your guess is for what percent of people that affects. All right, let's see what we're getting here. I'm seeing 40%, 52%, 75%. There's some good guesses. Seeing if anybody got it exactly right. Let's see. 85, 96. One more second to see if anybody hits it exactly on the head. I wish I had a prize for you if you did, but let's see who got closest. Okay, well, nobody seems to have gotten it quite right, but you're all kind of in the ballpark here. Pamela might have been closest here without going over if we're playing by Price is Right rules. Tracy just got pretty close, but I'll just go ahead and tell you guys the answer now. Thank you for playing. Let's see. It's 60%. So for those of you who practice in the world of criminal records and either help people with pardons or just aware of the pardons process, you know that the pardon process can take upwards of 4 years from start to finish. From the time you put in an application to the time you get that signed order from the governor saying you're recommended for a pardon. So imagine folks waiting for 4 years to get that signed piece of paper and then not having their record fully cleared after that. And, you know, there are a lot of reasons why that would be. You know, folks don't know that they need to then go file an expungement. When I explain that to people, they're like, what? I just went through this process for 4 years to get this signed piece of paper, and now you're telling me I have to go to another court and file another petition to actually get this off my record? Like, it's kind of crazy, right? So a lot of people just don't know. Some people might know, but might not have access to being able to do that on their own, might not know how to find all of you wonderful people around the state and legal aid programs to be able to help them with it. So there are all kinds of reasons why that number is what it is, but it's a troubling number given how much work and effort people are putting into that process. So the good news is, enter 9122.2A4 if you're looking for a citation to write down. The law now says that if you have criminal history that has been pardoned, pertaining to a conviction which has been pardoned, it's added to the list of criminal history that is eligible for automated limited access. So you might be asking, if you got a pardon, why isn't it just fully expungible through an automated process? After all, we actually have really strong case law in Pennsylvania that says if you've been granted a pardon, you have a right to an expungement. This is just another one of those things that politically in Harrisburg ended up getting changed to sealing because that's what happened in the legislative process. But at the same time, for those 60% of the people who are just not having their record cleared at all, you know, sealing is definitely a better step than nothing. And as we'll talk about, you can still file a petition for expungement for folks. So at least it's taking these records automatically out of the public sphere for people without them having to take any additional steps. So the procedure for exactly how this is going to work is not quite clear yet. We'll talk about the effective dates and go over them in a minute, but the Board of Pardons and AOPC have some time to figure this out. One thing that we have been told is that they do not expect this process to work in the same kind of automated way that Clean Slate does. Again, that's somewhat understandable in that this requires a different kind of interaction between the Board of Pardons and AOPC in terms of making sure people have actually been granted pardons before their cases are run. So it should be happening through an automatic process, but not through the same kind of automated process that other Clean Slate information is sealed through. The Board of Pardons has also expressed to us that it's their position that this is also going to be prospective only, so that it'll only apply to people who are granted pardons going forward. We disagree with that. I don't think it's supported by the statute. And unlike the automatic expungement piece, you know, the Board of Pardons has a list of people who have been granted pardons going back in time. So it seems to us much more feasible to be able to do this retroactively. So stay tuned for more on that going forward. But ultimately, like I said, for those of you who are in the expungement work world, you will still have the ability to file expungement petitions for your clients. That's our plan at CLS, is that we're still going to do full expungements for our clients who have gotten pardons. And the ceiling is really a helpful backstop for that 60% of people who, might not make their way to a legal aid program or otherwise know that they needed to do something to get it off of their record. So the effective dates for all of these, we've kind of talked about this in drips and drabs throughout, but just to kind of go over it one more time, because there are a lot of moving parts to this law and different effective dates for different portions of it. So the law itself went into effect 60 days after signing, which was December 28th of last year. So what that means, as Sharon explained earlier, is that you can be filing sealing petitions now for people who owe court fines and costs on their case. But AOPC, the Board of Pardons, and the state police have 365 days from the effective date to implement the other procedures, including automated sealing for court fines and costs and the pardon piece. Interestingly, our reading of the statute is that the automatic expungement for acquittals piece should already be going into effect, but we're not aware that that has actually started happening yet. We're waiting to hear more from AOPC about getting that piece off the ground. But the other pieces should all be in effect by December 28th of this year. And we'll start seeing, the biggest impact of that will be the retroactive sealing of all of the cases eligible, conviction cases eligible where court fines and costs are owed. Okay. So next on the horizon, what's up next? So for those of you who do this kind of criminal records work, I'm sure you'll share the sentiment that as great as Clean Slate 1 was and as wonderful as Clean Slate 2 is, it's still incredibly frustrating and disheartening to talk to a client who has a 20-year-old drug felony conviction on their record and needs a job right now, and to have to tell them, oh, you're going to have to wait 4 years to hopefully get a pardon in order to get that off your record. So the next on the horizon that we're hoping to see, what we're now calling Clean Slate 3.0, is a push to expand Clean Slate to felonies. There are a few components that we're focusing on. The first is for auto sealing to include drug felonies in the auto sealing provision. It seems like that makes a lot of sense. It seems more politically feasible given the current environment we're in. And we know from looking at data that it would have a huge impact on our clients around the state. So many people have drug felony convictions for very minor drug offenses that, completely derail people's lives. So the impact of being able to do that through automation will be, if we're able to be successful in it, will be enormous. We're also hoping to expand petition-based sealing to include other types of felony offenses, like there are a lot of theft and forgery and other types of nonviolent offenses that we would love to see as part of an expanded petition-based process. And finally, we're hoping to be able to shorten waiting periods by adding felonies into the mix. We don't want people to be waiting 20 years for a felony conviction and 10 years for a misdemeanor conviction. So hopefully we'll be able to use this as a prodding to shorten waiting periods across the board, to shorten the misdemeanor and summary waiting periods that are currently 10 years in the law, to put felonies at around 10 years, and to shorten some of the other waiting periods that currently exist in Clean Slate for if you have 2 or more M1s or 4 or more M2s. So just making everything a little bit more timely and in reach for our clients who, have already waited a really long time for relief. So I'm happy to talk more about sort of where we are and what we're thinking. Just to say a word about where we currently are. We're currently working on getting a draft proposal together and starting to talk to various stakeholders like the Pennsylvania DA's Association. We're also hoping to be able to do this campaign in conjunction with client and community-based groups of folks who have been directly impacted, especially by drug felonies, but other felonies as well. So we're kind of at the starting line and just starting to put all these different pieces together. But one thing that would be incredibly helpful for the folks on this call who work with clients around the state is that the dynamics in Harrisburg being what they are, people don't always want to hear from us Philadelphians and our Philadelphia clients. They like to hear from people around the state. So if you're working with clients or community groups in your area and you feel like they would be good partners to work on this campaign. We understand LSC restrictions being what they are, there are limits to what folks can do. But if you do have clients or community groups who you feel like would be good advocates for this campaign, definitely feel free to reach out and let us know and to put us into connection with folks. All right, so I'll stop talking now for a little bit and see if people have questions about either the acquittals or pardons piece of the bill, or if you have questions about the legislative campaign for a Clean Slate 3.0 or ideas you want to share with us. We would be happy to hear them now.
Jamie, maybe I could pipe in with a couple of other comments while we're waiting
Sure.
for questions. One thing I wanted to mention is that the Board of Pardons becomes ever more lenient about what cases they will pardon. I was on a town hall with the Lieutenant Governor, who is the chair of the Board of Pardons recently, and his message was, come apply, no matter what's on your record, come apply. So know that if you have clients who are willing to wait 4 years, that is looking like a really viable process right now. The other thing I wanted to mention is that how people's background checks look if they don't get cases that have been pardoned cleared. Now, in my experience, I have seen the Pennsylvania State Police record at least indicate that a case has been pardoned. So it still shows up, but next to it, it says -pardoned. That is not true in court data. There is no indication whatsoever that a case that's been pardoned has been pardoned. And the court data is what makes up most of the privately generated background checks. So a person who's gotten a pardon without that and gets first advantage to do a background check on them, it's going to look like nothing has occurred whatsoever to change their status. And that is why the retroactive application of Act 83 to Board of Pardons results is going to be really important, and why we will keep working on that.
Erica had a great question, which is whether we could ask the Board of Pardons to include planned contact info for expungement help when mailing out people's pardon decrees. It sounds like something they would probably be amenable to. I mean, for those of you who haven't been working as in the trenches on pardon stuff, kind of along the lines of what Sharon was just saying, we're kind of in a unique situation right now, and that Lieutenant Governor Fetterman, who will not probably be in this role much longer, but for the time he is with us, has been an incredible champion for the Board of Pardons. And then our current Secretary Brendan Flood, who he himself has been a recipient of a pardon and been through the process and really understands the barriers and burdens that it causes people, are both generally very receptive, within reason and in recognition that there are other members of their board who might not be as agreeable to certain issues, but especially for things like Erica's suggestion that are kind of more procedural, they're very open to ideas and suggestions. So that definitely seems like something I could see them being on board with, and definitely worth asking. Are there questions, comments, thoughts? Steve said it would be nice if we could get the governor to act on the approved ones. It certainly would. For those of you who might not be as familiar, once clients have already waited their 3+ years to get before the Board of Pardons and get recommended, the Board of Pardons then needs to send that recommendation on to the governor for his signature, and within his office they have their own vetting process for those cases that can sometimes take anywhere between 6 months to another year for folks. And I think that ends up feeling like one of the most frustrating aspects to people, because you feel like you've gotten so far and you're so close, you've been recommended, and then you end up waiting for a long time. And obviously the pandemic has made it a little bit more challenging for anything to move quickly in any of the systems that we work on. But there has been some increased media pressure and attention to that issue. And I think we just heard recently that another batch of pardon, if you're waiting on any clients to have their pardon signed, that another batch should be coming soon. So keep your eye out for that. But that's a great point. Any other questions, comments, thoughts? Okay.
I think we might take a quick bathroom break before Brendan starts at 2 o'clock, since we've got a few minutes. So how about if Brendan only has a half an hour, so I would ask that we start at 2 o'clock, but how about if we take a few minutes for some stretching and whatever else? See you at 2.
Just give the reminder, nobody needs to sign off. You could just simply walk away from your computers for a moment. You don't have to go through the hassle. We'll still be here when you get back.
I think we're recording, actually.
Yeah,
Perfect.
sorry if you were waiting for me. I stepped away for a minute, but we're ready to go.
All right, Kelly, do we need to do a poll, or
Sure, let's do that now and get it out of the way. So attorneys, please respond to the poll for CLE credit. You will have 2 minutes to do so, and go ahead and please begin. You don't have to wait for the poll. Thanks.
Thank you, Kelly. So I'm introducing my colleague Brendan Lynch from CLS also to talk about the other piece of criminal justice reform legislation that got passed last year. It's really kind of astonishing that we've had all of these things passed by the General Assembly in general, but even more so in 2020 when they were hardly at work. So Act 53, the Occupational Licensing Reform Bill, you have heard about before when Brendan and I did a webinar when it went into effect, but Brendan is going to, I guess, probably give you a little bit of refresher on that and tell you where we are with implementation. So with no further ado, I turn it over to Brendan.
Great. Hi, everyone. I'm Brendan Lynch, and I'm one of the attorneys in the employment unit at CLS, and I was part of the team that was involved in working with folks in Harrisburg and with stakeholders trying to get Act 53 passed, and we're pleased that it did. So I'm going to try to share screen here. Okay. And let's try to start from the beginning. There we go. Okay. So, so the scope of Act 53. I've cut out some of the detail about the reasons behind the drafting and the move to get the bill enacted, just for sake of time. But Act 53 was intended to remove some of the barriers that had been stopping people from getting occupational licenses unfairly and unnecessarily. So as it turned out, Act 53 applies to the approximately 29 boards within the Bureau of Professional and Occupational Affairs. So it does not apply to many workers in the state who are licensed outside of BPOA, and that includes teachers and lawyers, security guards. It also does not apply to nurse aides or certified nursing assistants. They're regulated by the Board of Nursing. And it also doesn't apply to the schools that train people in these professions. As it is written, it just applies to the licensing boards themselves, but it tells them how to consider criminal records in licensing decisions. And it sets new updated terms for how to do that. Just some information about who is affected by this. By far and away, the most populist profession that's affected is nursing. There are over 300,000 licensed nurses in Pennsylvania, and they are all covered. They are all regulated by the State Board of Nursing, which is part of the BPOA. Doctors are, of course, regulated by the Board of Medicine. Cosmetologists, beauticians, hairstylists are regulated by the Board of Cosmetology. There are also engineers, surveyors, geologists, pharmacists, real estate agents. And as I mentioned, there are 29, approximately 29 boards and commissions in all. There's one commission that I think has about 10 people, pilots on the Delaware River, maybe. But you can see some of them listed here. Some of the ones that we have seen in our practice most commonly would, aside from nurses and cosmetologists, would be barbers. As a matter of fact, probably the one thing that kicked off our determination to try to advance this reform was discovering that people were being denied the right to cut hair because they had been convicted of selling drugs. And we thought that that was stupid and counterproductive and outrageous. And so this, if nothing else, this law ought to end the denial of barbering and cosmetology licenses because of drugs convictions. There's also physical therapists, occupational therapists, social workers, and a number of others who perhaps we are less likely to see here in the legal aid world. So the new rules apply to all BPOA actions. That includes not only an initial decision on whether to grant a license, it also includes whether to renew it, whether to suspend it or revoke it or place limitations on it. So whenever a board is considering whether to grant, suspend, revoke, in any way impose discipline connected to a license on the grounds of a criminal record, they will now be required to apply the rules set out in Act 53. So there previously had been some of the practice acts. The term for the individual statutes that govern the individual professions is the practice acts. So the barber license law of, I think, 1931 is the Practice Act for barbers. And so there were some lifetime disqualifications for some types of offenses in some of the practice acts, and Act 53 explicitly says that those do not apply, except for the very limited set of cases that are explicitly set out for example, for sexual offenses for healthcare practitioners in the Act. But as a general matter, the old lifetime bans for BPOA boards will not apply. In addition, many boards started citing Section 9124 of CREA, the Criminal History Record Information Act, which had stated up until December that any board or commission had the discretion to deny a license based on any misdemeanor at all that was connected to the profession or any felony at all, regardless of whether it was connected. And so what did the boards do? The boards of barbering and cosmetology were actually instructed by the courts that their Practice Act did not permit denying people something, a license for selling drugs, for example. So what did those boards do? They started citing this provision. They started ignoring their own practice acts and just citing CREA as grounds to deny, because it was a felony, even if it was unconnected. Well, Act 53 explicitly says that boards cannot cite that. It does not apply to BPOA boards anymore. And to the extent that the practice acts had provisions about good moral character, crimes of moral turpitude, those provisions are explicitly overridden by Act 53. So the new method of considering criminal records is, first of all, they look to see if the applicant or the license holder has been convicted of an offense which is on the published list of offenses which are considered directly related to that profession. If the person has been convicted of one of those, the board is to determine whether or not the person would pose a substantial risk to the health and safety of clients or of coworkers or of future offending while on the job. And they determine that by conducting an individualized assessment. But they do apply a rebuttable presumption in favor of a substantial risk. The board doesn't have to determine that. The board certainly could look at someone who has a directly related offense, which by itself will create a rebuttable presumption per the terms of Act 53. But the board on its own could, for instance, note, oh, but this conviction is 30 years old and there's nothing since then. So the board certainly has the power to decide on its own that the presumption is overcome just on the face of the record. We fear that that may not happen very often. And so fortunately, even people who do have a directly related offense will have a clear opportunity to rebut the presumption and overcome the presumption by showing evidence of rehabilitation in the individualized assessment to show the factors that are considered in that assessment. For anyone who has a conviction which is not directly related, the board will then move on, and they will not impose any presumption will not be created by law, but the board will still nevertheless consider the facts and circumstances of any particular given conviction, so that there might very well be offenses that on their face appear to suggest possible dishonesty that might be interpreted as suggesting a propensity for violence because they're a crime of violence or a crime of dishonesty or a crime of theft, but are not necessarily on their face related to the work of the profession. The board can then look at the actual facts and may discover that in some situations what actually went on, the actual behavior that the person engaged in really did show that it was in some way connected to the profession. We assume that in most cases they won't, but the boards will have full discretion to do that. There again, that will not mean automatic denial of the license. There again, the person will have the opportunity to present evidence of rehabilitation. The board will conduct individualized assessment. So what it's going to be very important whether or not a crime is considered directly related because of that presumption. We think that the presumption, frankly, is going to be somewhat difficult to overcome for many people. Hopefully some of us will be representing these people. Hopefully some of us will be able to go to hearings in front of hearing officers and guide our clients in presenting evidence to overcome it. And again, the boards are required, even where there is a directly related offense, the boards are required to conduct an individualized assessment, and they are among the things they are required to consider is the age of the offense. So where that person has that 30-year-old conviction, the board has to take that into account. But nevertheless, in the way of things, and given the long history of the board's eagerness to find reasons to deny or revoke a license, to err on the side of being strict with people who have been convicted, we suspect that the way it will work in practice is that the presumption will act as a significant barrier. So it matters a lot whether a crime is considered directly related. And the Act 53 defines directly related as the nature of the conduct for which the person was convicted has a direct bearing on the fitness or ability to perform one or more of the duties or responsibilities necessarily related to the profession, trade, or occupation for which the individual seeks licensure. And BPOA is required to publish what it refers to as a schedule of disqualifying criminal offenses. And the schedule will consist of a list for each individual board of what offenses that board considers to be directly related. The commissioner and the various boards did, largely behind closed doors this past fall, consult with some stakeholders, not us, but with affected businesses and with other parties. And they did come up with initial proposed lists. And those boards, those initial lists were published on the board's website as of late December. And they did publish notice in the Pennsylvania Bulletin declaring that they had done this. The next step is that the lists have been made public. They have been released. They are going to be published in the Pennsylvania Bulletin for public comment. We anticipate this spring. We've heard that it may happen in April. There will then be proposed regulations within 2 years after publication of the list. The final list of offenses for the respective professions will be provided to each applicant and will also should be easily available on the board's websites. And the boards will use those lists for discipline, for granting licenses, for making preliminary determinations about someone's eligibility, which we'll get to a little bit later. How am I doing on time? So we do have some concerns about the preliminary lists that have been released. The Barber Board's initial proposed list of directly related offenses suggested that they viewed possession with intent to deliver, and DUI, and reckless endangerment of another person, and various theft crimes as being directly related to the profession of barbering. That seems to me like utter nonsense. That seems to me like taking a variety of offenses that could possibly apply to some people in some circumstances, some things that may suggest a very general propensity to engage in possibly antisocial behavior, and declaring that they are directly related to the practice of barbering. And I just think that's, clearly wrong. But there's been a pattern of that with the lists, pretty much every list that we have seen so far, except for the Navigable Waters Commission, because they said that there was not a single directly related offense. Bless them. They took it seriously. They thought about it and they said, is anything related? You know what? It's not. And they actually said that, to their credit. But just about every other board that we've seen has come up with things that we think are clearly not directly related. Cosmetology wants to say that various theft and fraud offenses and reckless endangerment are directly related to the practice of cutting and styling hair. The Occupational Therapy Board wants to include theft and fraud offenses and perjury and various impersonation-related crimes. Physical therapy wants to include endangering the welfare of a child. There's simply nothing necessary about having children around to practice physical therapy. It's just simply not required. Again, it may happen in individual circumstances. And with all of these things, every single one of these boards will have and would have the opportunity to review the facts and circumstances of any given individual conviction. But they're proposing to oppose a presumption for anyone who has any of these things. And for the nursing board, it's not quite the entire crimes code, but they put out a list which is over 6 single-spaced pages long of offenses that they claim are all of them directly related to nursing. So as I just mentioned at the bottom here, directly related offenses are not supposed to be an automatic barrier. And the nursing board did declare when they put out their list, hey, we're not saying we're going to automatically deny for these things, but they are saying that they will pose a significant barrier to people who have these offenses. And some of these things are very, very common. As Jamie Gullen was mentioning in the last session, PWID in particular, possession with intent to deliver, extremely common offense, and should not be a barrier to people, I feel. So the factors in the individualized assessment. I just want to, just before I go on, I don't know if I spelled this out in the last slide, but I did want to say just where we are right now, today here on March 5th, is that we are anticipating, as I said, that the list will be published for public comment in the Pennsylvania Bulletin. And I want to take a brief moment to put in a pitch for people to consider weighing in, to consider making comments. The list will be considered by the IRC as part of the regulatory process. And to the extent that people feel their client populations would be hurt, to the extent that people feel that a rebuttable presumption applied over broadly would impose a burden, especially on unrepresented people seeking to better themselves, seeking to re-enter the economy. To the extent people have evidence and concerns about that, people will have a chance to weigh in. And I want to encourage people to do that because these lists can be changed. We anticipate they will be changed after notice and comment. And people here can help ensure that that happens by participating in the notice and comment process once they've been published. So the individualized assessment that the boards have to conduct is supposed to look at 11 different factors. It's supposed to look at the nature of the criminal conduct that was involved, particularly if there was an act or threat of harm. But also more generally, just the facts and circumstances around any given conviction, the number of convictions a person may have, the increase in age and or maturity, hopefully both, of the applicant since the date of conviction, the applicant's criminal history, if any, after conviction, and that certainly should include the absence of any criminal history since the conviction, and that should certainly be the absence of further conviction should certainly weigh in the person's favor, and the board should be required to take that into account. The completion of any education or training, including an incarceration, which is often the case for people who have been barbers or cosmetologists, references from employers or others, evidence of personal rehabilitation, and that's not further defined, so that can be anything at all. Anything that appears to be relevant, that might help to convince a board or a hearing officer that the person has changed their ways and is no longer a risk to commit crimes. Anything like that can fit into category number 8. And plus there's a catch-all at the end, any other factor at all deemed relevant to the person's fitness to practice their profession. And also if the person meets other licensing requirements. And lastly, if the person did commit crimes, was found to have committed crimes while engaged in the occupation. That will certainly be relevant. It will certainly count against them. But in most cases, they will not have done that. And that should, it should be noted that that factor does not apply to them, and the board should take that into account. There are some carve-outs. There is a list of sexual offenses, and those create a lifetime. If you're convicted of one of those, there is a lifetime ban for healthcare practitioners. And healthcare practitioners can be somewhat of a broad category. I believe occupational therapists actually are considered healthcare practitioners. So for a number of fields, there are a number of offenses that do essentially create a lifetime ban. There are also crimes of violence. If you have been convicted of one of these serious crimes of violence that are set out in the list, which is, and they're specifically enumerated at 42 Pennsylvania Consolidated Statutes, section 9714, paragraph G. If you've been convicted of one of those, then there will be a bar unless you can meet these additional conditions, that you be crime-free of at least 3 years since release from incarceration or imposition of sentence, and you have to show significant rehabilitation. In addition to the board concluding that you do not pose a substantial risk. For drug trafficking, there's no kind of general bar for drug trafficking. The Act 53 says that if the Practice Act says that drug trafficking offenses will be a bar to licensure, then that provision of the Practice Act is to be defined in terms of serious drug trafficking. And basically, the Act says that there has to be a substantial amount or weight of drugs involved. So that the idea being that people who get convicted of PWID, which is a felony, but when you look at it closely, it was really a fairly small amount and frankly could easily have been for personal use. That person should not be subject to the drug felony bar that you find in many of the Practice Acts, only when someone appears to be a genuine trafficker, engaged genuinely in a practice of trafficking drugs. And the burden is on the board to show the amount. And frankly, in most cases, it will likely be somewhat difficult to prove the amount because it's not listed in court records. But that's up to the boards. If they want to go spelunking through various court files trying to dig that up, they can use whatever powers they have, then the burden will be on them to show that the amount involved in order to show that the felony ban of the Practice Act actually does apply to any given applicant. There are restricted licenses available for barbers and cosmetologists. And the Act actually says that essentially there are two parallel provisions, one which refers to barbers and cosmetologists, the other refers to anybody else who is trained while incarcerated. We have not discovered evidence that they are currently training for licensed professions other than barbering and cosmetology within state correctional institutions, but there may be some, they may add some in the future. So Act 53 says that even where they have a conviction that might bar them from working in the field, folks who have been trained for a profession while incarcerated can nevertheless get a restricted license. The license, as long as they meet the other conditions for qualifying for a license. The restricted license will last 1 or 2 years. There are criteria for fitness to hold a restricted license. The board can impose conditions, which can include supervision by a current licensee. And of course, it can be revoked if someone slips up. But at the end of the restriction period, the supervisor is supposed to tell the board whether the person met the conditions and complied successfully with the expectations. And if so, the person will then receive a regular license. So it's almost a sort of probationary license that you can get if your training occurred while you were within a state correctional institution. And then there are going to be preliminary determinations if people have questions about whether or not they will be denied a license. Because of the somewhat subjective standard that's going to be applied to people who have records where they have a crime that's not directly related, and they will have a guaranteed opportunity to make a showing of various factors. It's not really possible to say with utter certainty whether any given individual qualifies or is clearly disqualified from licensure just strictly on the fact of the record. But one thing that can be told is whether or not the crimes that they have are directly related. And so the Act provides for people to petition for a preliminary determination where if it's not clear to them, they can get a decision within 45 days declaring whether or not anything they've been convicted of is directly related, and therefore whether they will face a presumption of substantial risk. Many people won't need to do this because the lists of directly related offenses, as we said, will be available on the web. And there's also going to be a guide, which I mentioned in this next slide. And so people will be able to view that for free. So the determination is really if your record is simply unclear to you, if you're not sure what it says, if you review these materials and you're not sure, you just have some confusion afterwards, or if you're applying to some school, if some school is going to set up some kind of requirement that people provide confirmation that they're likely to be able to get a license prior to being allowed to enroll, people may want to get that in order to show to a school. Act 53 makes clear that people cannot be denied a license based on an expunged or a sealed case or a juvenile adjudication. And again, there's supposed to be a best practice guide. In fact, they have already put up a preliminary version, which from what we've seen appears to incorporate the preliminary lists. But since the lists are not finalized, in a sense, the guide is not finalized. And actually what they've put up is pretty legalistic and not very client friendly. But nevertheless, there is a best practice guide that is already available. And we're hoping that that will be improved over time and will come to be something that is genuinely helpful to lay people. Enforcement, as before, there are licensing hearings, the same provision that has always been in place for people to get a rule to show cause, to request a hearing in front of a hearing officer, and then to have a recommendation made to the board to take final action, and for people who disagree with that to appeal to Commonwealth Court. So that's almost all of my time. There was just a slide there about highlights. But I wanted to leave just a couple minutes for questions if there are any. Deborah Steve says it would be nice if we could get the governor to act on the approved ones. And she was talking about pardons. But I want to say if the governor could approve occupational licenses for people with records, I would kiss him. He can't. Any other questions?
Brendan, that was quite a wrap up to your presentation. All right, well, I think we're almost at time, unless anyone speaks up with their question promptly, we will move to the next panel. We had done a poll just before Brendan started, so I think probably the next one won't be until toward the end.
You're correct on that, Sharon.
All right. I channeled you well, Kelly. All right, then Brendan, we thank you for covering Act 53 for us. And as Jamie and I are available for questions about Act 83, Brendan certainly would be willing to consult with you on any Act 53 cases. So please reach out to him, and we will keep you up to date with what's going on with the IRC process and getting these lists hopefully trimmed down. All right, next panel. Are you ready to go? While you are readying yourselves, there comes Nina. Hi, Nina. I'm going to introduce the panel and then let them take it away. Nina Minetti, who is here on my screen at least, and I guess that means yours also, graciously agreed to do this panel with not a lot of advance time for the request. That's true for her co-speakers as well. Liz Chaco, Nina and Liz are both from Justice at Work, which used to be known as Friends of Farm Workers. Some of you old timers like me may remember it by that. And also, I think we have in the panel today, Mariel Macher. Is that right? Mariel is joining us. Mariel is with the Community Justice Project. So, and she's got a very interesting case there going on with occupational safety issues that I'm sure she'll talk about. So without any further ado, I'm going to turn this panel over to Nina and her co-presenters. They're basically talking about the other side of the coin on the pandemic and the recession from the unemployment benefits, which is if clients are working, how do they keep themselves safe? And if they need leave, how do they get that? So with no further ado, Nina and panel, take it away.
Thank you, Sharon. Okay, I'm going to share my screen. Okay. All right, so as Sharon said, my name's Nina. I'm from Justice at Work, and today I'm going to be talking about pandemic-related employment tools. For those who aren't familiar with Justice at Work, we have offices in Pittsburgh and in Philadelphia. We provide free legal aid, community education, and advocacy for workers across all of Pennsylvania, and we support low-wage workers as they pursue economic and social justice. Here's some lists of some current projects and issues that we work on. Okay, so today I'm going to be talking about pandemic-related employment tools, as I said, and I'm going to start by presenting this as sort of a toolkit. So there's not really one piece of legislation or any existing laws or sort of causes of actions that exist to address the wide variety of issues that come up for workers during the pandemic and because of COVID-19. And for that reason, I'm going to present this as like a series of tools that you could use if a worker has a problem at work related to the pandemic. So I want to start by touching on what we've seen over the past year. As everyone knows, the pandemic started really in the US about 1 year ago exactly. The first big change we saw pretty early on was the advent of the Families First Coronavirus Response Act, or the FFCRA, which I'll be talking about more. That was in like April of last year. And it changed things quickly, but by becoming the first like federal mandated paid leave that has existed in the US. And it provided leave, either sick leave or more extended emergency leave for varying reasons related to COVID-19 for workers. And then we saw also from the beginning a series of Pennsylvania like emergency orders from the Department of Health that put in place rules on what employers must do to protect their employees and the public if their businesses remained open. Of course, for a while, some businesses pursuant to these orders had to shut down. So there's just been so many different sort of iterations over the past year. And I'll talk a little bit about what we have now. And then I'll talk about OSHA. So in 2020 and for the first year of the pandemic, basically, OSHA was taking pretty limited action to protect workers, employees in workplaces from COVID-19. The guidance that they put out and the sort of recommendations they made to employers based on what the CDC was recommending at the time were just that. They were recommendations and sort of guidance or suggestions of what employers could do to protect their workers, but they weren't like mandated steps that the employers must follow to protect their workers. And of course, there was widespread infection rates in workplaces across the state and across the country. In certain industries in particular, employees were becoming infected at work at really high rates. And despite OSHA receiving, I think the number was around 13,000 complaints from workers, they only acted on a fraction of those complaints, and they only issued a very small number and amount of citations and fines for employers for not taking the appropriate steps to protect their employees during the pandemic. The current landscape, the FFCRA expired or expired in its former state at the end of 2020. There's of course a new administration and there are new OSHA guidelines, which I will talk about. And then the Department of Health and the Governor's Office of Pennsylvania has continued to issue and amend the emergency orders. I'll talk about what we're seeing now as well in a moment. So because there's not really one cause of action or sort of one size fits all solution for the many different problems that workers have experienced because of the pandemic, I'll talk about a couple different existing laws that just to sort of get people thinking about when a worker comes to your office or a potential client has issues related to their workplace in COVID-19. So I'll talk about the Fair Labor Standards Act, which is FLISA, the Family and Medical Leave Act, FMLA, Americans with Disabilities Act, the ADA, and OSHA. So as I said, and I just want to make very clear that the former provisions of the FFCRA expired on December 31st, 2020. So the FFCRA provided paid sick leave and a more extended emergency family and medical leave for specific reasons related to an employee becoming ill with COVID-19 or for someone they care for becoming ill with COVID-19 or for people to provide for childcare when a child's school or place of care was closed because of the pandemic. And under the original provisions of the FFCRA, employers that were covered by the FFCRA, a notable exception was that they had to be an employer with less than 500 employees, but employers who were covered were required to provide leave under the FFCRA. On December 31st, that expired. So now employers are not required to provide leave under the FFCRA. However, they may still voluntarily provide paid leave if that leave is still available to the employees. So that means that employees must not have exhausted all their available leave time available under the FFCRA. It hasn't sort of re-upped that leave amount. And employers, the way that the scheme worked under the FFCRA originally was that employers would provide leave and then receive like a dollar for dollar tax credit for the leave that they provided. Now, if employers choose to provide the paid leave, they can continue to receive the tax credit until March 31st of this year. And there may also be an extension of that tax credit system, which I'll talk about in a moment. But now it's voluntary, not required, unfortunately. So back in 2020, when an employee would say that they believed they were eligible for leave, but they were either not given the leave, or they were retaliated against for requesting the leave, or they were retaliated against for taking the leave, that would immediately make us think that, that could be something that could be put in a demand letter or used during a negotiation with an employer, or there's even a private right of action. At the bottom of this slide, I just wanted to mention that the FFCRA was an amendment to the FLSA, to FLISA. And so the statute of limitations is the same as under FLISA, which is 2 years from the time of the last violation, or 3 years for willful violations. So although providing paid leave currently is not mandatory, if an employee is talking about a situation that happened before the end of last year, they could still have a claim there. And claims can be made by either filing a complaint with the Department of Labor Wage and Hour Division, or there is a private right of action. We've also written just demand letters that sort of just demand these in the same way that we would demand any wages under FLISA. So just to keep that in mind, if someone comes in and they're talking about violations that happened last year, it could still be actionable. Okay, just a brief overview of the FMLA, which was an existing law that was, it's been around for years and has nothing to do specifically with COVID, but I wanted to give a brief overview of the provisions of the FMLA and talk about ways that it can be potentially used in relation to the pandemic or COVID-19. So the FMLA provides for 12 weeks of unpaid but job protected leave. And it covers these employers, private employers with 50 or more employees, state and local government employers, schools, military employers. And a covered employee is someone who has worked for the employer for 12 months prior, and they must have worked for at least 1,250 hours in the past 12 months for the employer. So the way the FMLA could come up in the context of COVID-19. So the FMLA could cover employees who have contracted COVID-19 and complications arose for them. So as everyone I'm sure knows, COVID-19 affects different people in different ways. For someone who had to miss or has to miss a significant amount of time and be absent from work because of COVID-19 and complications that arose from it, this could qualify as a serious health condition under the FMLA, depending on the circumstances. This would also cover potentially family members with COVID-19 who experienced complications and required care from the employee over a longer period of time. However, this would not cover leave taken to avoid contracting COVID-19, and I'm going to talk about that a little more in relation to the ADA, but FMLA leave could not be taken to sort of like preemptively avoid potential infection from COVID-19. The FMLA would also not cover leave taken to care for healthy children whose school or place of care is closed. So as I mentioned, the FFCRA had an emergency extended FMLA provision that was for children who were home from school or their place of care because of the pandemic, the regular FMLA does not cover leave to care for healthy children. Okay, so we're also hoping that there will be some new paid leave legislation in the coming weeks, months, or even years under the current Democratic Congress. The American Rescue Plan, which is the bill that's currently before the Senate, is, I think, currently has in it an extension of the tax credits for employers who voluntarily provide leave. As I said, that's due to expire at the end of this month, but depending on how this sort of shakes out in the Senate, this could be, the tax credits could be extended until September of this year. And the provisions would be similar to those under the original FFCRA, so all the qualifying reasons for taking leave under the FFCRA. It may also include vaccination-related leave, so leave taken to actually get a vaccine, or leave taken because of the effects of a vaccination. Like if you get sick after you're vaccinated, it would cover that leave. Again, it wouldn't be mandatory under the bill, and you know, we're not sure what the final legislation will look like as of now. So President Biden's original American Rescue Plan also included new emergency paid leave legislation that was similar to the FFCRA, but covered more employers and more employees. So that didn't make it into the bill that's currently before the Senate, but because it was in the president's original plan, there's hope that some new emergency paid leave legislation will be introduced soon. So not specifically related to COVID-19, but a more long-term solution is the Family Act, which would provide for possible paid leave with similar provisions to the FMLA. So the Family Act has actually been pending for several years, but now with a democratically controlled Congress, there's hope that paid FMLA leave would basically have the potential to actually happen, and that would be a long-term solution because there's no federally provided paid leave now. Okay, and I wanted to just briefly touch on the ADA as well, because there are so many ways that the Americans with Disabilities Act could interact with the pandemic and COVID-19. So just a very brief overview of one of the things that the ADA does. It requires reasonable accommodations for individuals with disabilities absent due hardship. So that's just one thing that the ADA does, and it does other things as well. But basically, it's for an employee who has a disability in the workplace. An employer must provide a reasonable accommodation as long as it doesn't cause an undue hardship on the employer. So it's not clear yet whether COVID-19 symptoms or complications themselves could be considered a disability. It's just not really established yet whether that would, what the long-term effects of COVID-19 are, and the law has not established whether or not that would be considered a disability. However, there's a variety of different ways that someone who has a disability could be impacted by COVID-19 and receive a reasonable accommodation. So having a health condition that puts an employee at a higher risk for COVID-19 could be the basis for a reasonable accommodation, for example. So for the number of different health conditions that like put employees at higher risks for contracting COVID-19, if an accommodation could exist that would allow the employee to protect themselves from potential infection. For example, if an employee could telework and that allowed the employee to continue to do all of their like the essential functions of their job, and that didn't present an undue hardship for the employer, that would be an example of an accommodation to make it easier, more manageable, and safer for that employee to continue working. And it doesn't even have to be just the health condition that puts you at a higher risk for COVID-19. As everyone knows, the pandemic itself and COVID-19 has impacted workers' lives in so many different ways. Related to work, telework, vaccinations, and there's really no way to summarize all the different ways that like a physical or mental illness could have been impacted by the pandemic, or ways that an employee's individual work situation could be made possible or more manageable given a reasonable accommodation. So I just wanted to mention the ADA so that if you hear from an employee who expresses that COVID-19 has sort of changed the way that they're able to work, or it's affected their ability to do their job in many different ways, you could think about the potential for a reasonable accommodation under the ADA. Okay, I'm going to talk about health and safety in the workplace now. So outside of COVID-19, just in general, there's a right to a safe and healthy workplace under the Occupational Safety and Health Act. Pennsylvania is subject to federal OSHA, so it's not a state plan state. Like there are other states, including, for example, California, that have state OSHAs that make their own standards and enforce them. Pennsylvania does not have a state OSHA, so we rely on the federal OSHA's standards, guidelines, and enforcement. A new set of OSHA guidance came out on January 29th of 2021. Although they are guidelines and they're not like a standard that I'll talk about in a second, they had a sort of a more specific and a more forceful tone to them than the previous guidelines did under the previous administration, and also based on President Biden's executive order that came out on January 15th. It was also more like had a stronger tone in talking about enforcement. So we're hopeful that enforcement will be just more, it'll actually be happening going forward. And the guidance had a few, these are just some examples of some of the provisions in the guidance, but some important ones are that the guidance encourages employers not to have policies in place that would punish employees for being absent from work for any reason, which is something that we have seen employers doing over the past year. Policies that basically encourage workers to come to work even if they're sick, increasing the risk of harm to themselves and their coworkers. Also implementing protections from retaliation for employees who do make complaints about the way COVID-19 is being handled in the workplace, and making vaccines available at no cost to employees who are eligible. So according to President Biden's executive order, the Department of Labor has until March 15th, which is 10 days from now, to determine whether an emergency temporary standard is necessary and to issue it if they determine it is necessary. And an emergency temporary standard would be a set of more like concrete and enforceable standards that employers must follow to protect their workers. Okay, and the last thing I'm going to talk about is the Pennsylvania emergency orders. And as I said, and as you all probably know, there's been a series of orders which have changed the landscape for workers over the past year. There's a helpful checklist on the website listed at the bottom of this slide that says like exactly what employers must be doing right now to protect their employees. And some of its contents are listed here. Notably, telework must continue unless impossible. Masks must be worn at all times, and employers must provide the masks. And then a lot of the same things we've been seeing since the original Secretary of Health order last April, which says employers must provide for social distancing, limit gatherings, and create and execute a plan for COVID-19 exposure in the workplace. Okay, now I'm going to turn it over to Marielle to talk about her meatpacking case, which is an example of a workplace health and safety case.
Hello, everyone. Kelly, is it possible for us to turn off the recording for a little bit, because I'll be speaking about some active litigation.
Describe actions taken by workers who engage in concerted actions for their mutual aid and protection. There are a couple of, you can go to the next slide, please. We're going to talk a little bit about what the statutes are and who they protect and who they don't protect, and then more specifically, actions that workers can take. So there are a couple of statutes that are at play here, and that there's the National Labor Relations Act and then the Pennsylvania equivalent. We're going to focus on the discussion about the National Labor Relations Act today. It's probably easier to talk about who's not protected because most employees are protected by the National Labor Relations Act. As you can see, some of the workers who are not protected are the same types of workers in the same industries that are excluded from protections, the protections of other employment laws. So agricultural workers, independent contractors, domestic workers are not covered by the protections of the NLRA or the PLRA. Likewise, supervisors and managers, and federal government employees, although they're covered by a kind of an equivalent statute. So most of the workers that you see who are coming into your office will be covered by the National Labor Relations Act and afforded its protections if they're acting with another worker for their own benefit at work. Okay, so this is from the National Labor Relations Act, and it states, among other things, that workers have a right to engage in concerted activities for the purpose of mutual aid or protection. And I want to break that down so you understand what it means. We can start with what concerted means. So an activity by a worker is considered concerted where it's engaged in, with, or on the authority of other employees, and not solely by one employee alone. A single employee may be acting in a concerted manner, though, if they're bringing a group concern in some situations, and especially if there's some kind of evidence of a prior or contemporaneous discussion of a group concern with other workers. And concerted activity might also be found where an individual employee communicates with at least one other employee with the intention of preparing for group action in the interest of more than one employee. And then when we're talking about mutual aid or protection, the concerted activity must be aimed at changing the employer's policies or practices. And so essentially it must be about some matter that is within the employer's control. And one example I like to give is So customers' tipping habits are not within the control of an employer, but wages, for example, paid by an employer are. So the National Labor Relations Act defines a set of prohibited actions. Some of them are listed here as unfair labor practices. This isn't a comprehensive list, but I've included some of the ones that are relevant for our purposes. And as you can see, it's an unfair labor practice for employers to interfere with workers who are engaging in concerted protected activity. And it's also an unfair labor practice for employers to discriminate or retaliate against workers who engage in concerted protected activity or file a charge or a complaint with the National Labor Relations Board, or who testify before the board. And the board is the enforcement authority behind the National Labor Relations Act. So there are many different types of actions that are protected, and that would be considered a concerted protected activity. And I just have some examples here of ones that we've seen over time, and especially during the pandemic. So demands that are made either in writing or verbal demands for improved working conditions, or any demands relating to the terms or conditions of work are protected. And this includes demands and also conversations that workers have in person or online among themselves, as long as they're talking about, as long as those conversations include discussion of terms and conditions of employment. And when we're talking about terms and conditions of employment, this can include discussion of wages, benefits, safety issues. And again, like I want to just emphasize that this concerted protected activity can happen online, and we've seen that more in recent years, but that it must be concerted. So a single worker who's making a rant against their employer on their social media page may not necessarily be protected by the National Labor Relations Act. Some other forms of action that we've seen recently are work stoppages and protests, or like drive-by protests. There are some work stoppages that are protected and some that are not protected. So generally, non-unionized employees, which is the vast majority of the workforce these days, do have a right to walk out or otherwise stop work as a form of protesting the terms and conditions of their employment. But if a work stoppage, if there are intermittent, wouldn't be considered protected if it's relating to the same concern or demand, as opposed to multiple different issues. And then slowdown strikes, where employees are kind of withholding some portion of their work or slowing down, those are also not protected. Protests can't be violent or in breach of contract for them, and if so, that those are not considered protected. So concerning with respect to the pandemic, the Act protects employees who are protesting what they believe to be unsafe or unhealthy working conditions. This is from the Tamara Foods case. And, you know, this is the case even if an employer states to their workforce that they've taken certain safety measures to keep workers safe. So even if that's the case, and the workers can engage in collective action and still be protected. And then again, if the workplace has been deemed safe by OSHA or another government agency, it's still not sufficient to make any kind of action, collective action taken by the employees to make that unprotected. That's still permitted. I think it's also important to note that workers don't have to demand that the employer take specific action, any sort of specific action to address their concerns. related to workplace safety. So, you know, employees aren't expected to be public health specialists and make certain demands. That can be they can ask the employer to do that, right? And you know, they don't need to do that before they go on strike or engage in a work stoppage. And then one final thing I guess I would say is that employees can refuse to go to work if they have a reasonable good faith belief that working under certain conditions would not be safe. So even if they're mistaken, the Act protects employees who are honestly mistaken in their belief about workplace health and safety. And then I just want to wrap up by talking about remedies and kind of some logistical matters. So remedies for violations of the National Labor Relations Act include reinstatement and back pay. So this is limited. The remedies can be limited for undocumented immigrants, which is unfortunate, and something that we always hope will change with every new administration. And the way to file a complaint with the National Labor Relations under the National Labor Relations Act is to submit something called a charge with the National Labor Relations Board. It's just a simple one-page document that that you can fill out pretty easily. That has to be filed within 6 months of the unlawful behavior, the unfair labor practice. There's a much shorter statute of limitations under the Pennsylvania equivalent, the Pennsylvania Labor Relations Act, but that doesn't, the law doesn't apply to very many workers who we would be seeing. And I think that's it, and we have time for questions.
Hi, Liz. This is Kelly. If I can just interrupt quick, I need to launch the last of the CLE polls.
Sure.
So attorneys, it should be on your screen now. You'll have 2 minutes to respond to the poll. And Liz, please feel free to continue. Thank you.
I did see one question from Rhiannon about enforcement by DOL of FFCRA violations. And I don't know if Marielle or Nina want to respond to that. I know we have filed a couple in our office and haven't really seen any action taken by the Department of Labor on those complaints, and have had more success negotiating on our own with defendants.
Yeah, I would just confirm that that's what we've been seeing. And although the Department of Labor is supposed to be enforcing the FFCRA, we haven't seen that actually happening at all, or at least not yet. However, I do think it can be sort of a good like bargaining chip or a part of a demand letter, as I said, to discuss the obligations of the employer under the the previous version of the FFCRA that was mandatory, at least, and that has I've experienced some success with that, and some employers who are just genuinely maybe not aware of their obligations under the FFCRA, or willing to settle for an amount that the employee is owed under the FFCRA.
Any other questions?
Two quick things I wanted to mention, following up on what Marielle and Liz said a bit. One is that we heard from Marielle about her Title VII complaint, and I wanted to mention this as another tool, as she said, not just in relation to the way that health and safety is being handled in the workplace, but could also apply in a variety of circumstances based on how an employer is treating its employees. Even if leave time is not required, they don't have to provide leave time, or if there's some issue related to an employee's disability, it's important to remember that they still have to provide it in a way that's not discriminatory based on one of the protected categories. So just to keep in mind that if you see an employer's own policies being applied in a discriminatory way, that could also be sort of a tool to think about. The last thing I wanted to say, which I meant to mention earlier, is that if you do see any of these issues arising for callers or potential clients, that Justice at Work has been working on cases like this over the past year. Of course, we can't promise that we'll be able to take any one case or any one type of case, but we do encourage you to refer these cases to our offices in Pittsburgh and Philadelphia, and the information on that, on how to refer, was on the last slide of the PowerPoint. Are there any other questions?
Well, if there are no more questions, first I want to thank the speakers, Nina, Liz, and Mariel, for a lot of great information that maybe a lot of us don't confront on a daily basis, but obviously provides key tools for our clients who are working, especially those essential workers who've been taking care of the rest of us ever since this whole mess started. So thank you so much for that panel. I'm pleased to tell you that it looks like we'll be able to dismiss you a little bit early this Friday afternoon. After you've listened to so much talking, we thank you so much. I'm sorry that we could not get together. I miss a lot of you who I've known for a long time. And for those many of you who I don't know, I'm sorry I missed getting to know you, and hopefully either in time for the planned conference in the fall or next spring, we'll be back together soon. I will say that on a positive note, we had extremely high attendance today. We started with about 125 people, and we've still got about 80 on the Zoom. So that's tremendous. That's an advantage of us not having to schlep to Harrisburg. So yay for that. And I guess the last thing to address is just where can you get the PowerPoints if you don't have them, because I'm sure you'll want to consult a lot of the information you got today later on when it becomes directly relevant to you. So Kelly, what can you tell us about that?
Sure. I would just remind everyone, or if you're hearing this for the first time, today's session was recorded, so it will be available on the Plan YouTube channel. If you are a staff person in a Plan Network member program, on the Plan website, the Brief and Information Bank has recordings of all trainings and all the materials. Give us probably until next Monday or Tuesday to get that up. I will also be emailing the PowerPoint materials out to all registrants for today's sessions, either this afternoon, or if you take mercy on me, probably Monday. But we will send materials out, and you can also find the recordings and the materials in the places that I indicated.
Kelly, I know you have a long week. I was on the Zoom yesterday, and I know you've had other programming. So yes, we will take mercy on you, and I certainly hope that you are going to wait until Monday to do that. If anyone is in dire need before then, email the speakers involved, and I'm sure they'll be happy to provide you with what you need. But again, thank you all. I know it's exhausting, especially on a Friday, but we've made it to the finish line. Thank you to the speakers. Thank you to the attendees, and we will see you next time.
Thanks,
All right.
everyone. Have
Bye,
a great
everybody.
weekend. Be safe. Take care. Maybe sometime soon we'll see you in person.
Exactly.